Thank you. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are also present. Is Mr. Poirier here with his counsel? Where is he?
He's not present in the courtroom. He is.
Could you get him and Ms. Gonzalez? I need to make a record. Mr. Poirier, if you would come up to the podium with your counsel, please. Would you raise your right hand and take an oath, please?
You do solemnly swear the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Sir, if you are called as a witness in this case, you will be subject to cross-examination. On cross-examination, defense counsel intends to ask you about your involvement in certain criminal activity for which you have not been charged or convicted at this point.
Ask Mr. Santos?
Specifically, your involvement in the unlawful distribution of steroids, prescription fraud,
Do you know that you're giving up that right?
and the sale of fake Rolex watches.
Permit the defendant to
Under the United States Constitution and the state constitution, you have a right not to incriminate yourself. I've appointed legal counsel to advise you about that
the state
right.
has indicated it wishes to.
But your decision to exercise your privilege not to incriminate yourself must ultimately be your
While
own.
that appeal is pending, you
And
can't
so
change
I need
your
to
mind
ask you about that.
waiving your right to a speedy trial.
On
while the appeal is
cross-examination, when
That
you
this
are
will
asked
bind you
about your
throughout that appeal
involvement in
period.
the
You understand
unlawful
that?
distribution of
What that means is you
steroids,
can't decide
do you
3-4
intend
months
to
from now,
answer questions posed
while
to you
the appeal is
or
pending
to
and
exercise your
thinking that the
Fifth
appeal might take
Amendment
a long time,
privilege?
that, I think I want to put the state to its
On
proof here.
cross-examination, when asked about your involvement in prescription fraud, do you intend to answer questions posed to you or to exercise your Fifth Amendment privilege?
Yes, it was. Okay. Do you have any questions
And
that you want to
finally,
ask the
on
court about this?
cross-examination, when asked about your involvement in the sale of fake Rolex watches, do you intend to answer questions posed to you or exercise your Fifth Amendment privilege?
Exercise my Fifth Amendment.
Thank you. You may be seated. And did you state your appearance for the record, Ms. Gonzalez?
Barbara Gonzalez representing Mr. Jason Poirier.
Thank you. Thank you. You may be seated. The defendant moves to strike the direct testimony of Jason Poirier. I'm going to refer to him as the witness on the ground that he intends to claim his Fifth Amendment privilege against self-incrimination on cross-examination. Specifically, the witness intends to claim the privilege when asked about his involvement in the unlawful distribution of steroids, an activity which the witness openly discussed with his wife on a jail telephone, which was monitored by jail personnel. The fraudulent obtaining of prescription medication from a medical doctor, and the sale of fake Rolex watches. The state opposes the motion. The state argues that the questions related to other crimes are collateral and relate only to the witness's general credibility, not the testimony which will be elicited from the witness on direct. The state further argues that there are effective alternative means of impeachment such that the witness's direct testimony need not be stricken. Having considered those arguments and the legal research which I have done and which has been argued and presented to me, in determining whether the testimony of a witness who invokes the privilege against self-incrimination during cross-examination may be used against the defendant, federal courts distinguish between instances in which, one, the assertion of the privilege merely precludes inquiry into collateral matters which bear only on the credibility of the witness, and two, cases in which the assertion of the privilege prevents inquiry into matters about which the witness has testified on direct. Where the assertion of the privilege merely precludes inquiry into the general credibility of the witness, for example, the witness is a liar, the witness may exercise the privilege without requiring that the witness's testimony be stricken. However, where the assertion of the privilege prevents inquiry into matters about which the witness has testified on direct, for example, the witness is lying right now, all or part of the witness's testimony may be stricken because the defendant's right to confront and cross-examine the witnesses against him is compromised. However, when it comes to state witnesses who exercise the privilege on cross-examination, it appears to me that the Utah Supreme Court has not classed inquiry into credibility as a collateral matter. The reasoning of the court in State v. Leonard is instructive. In Leonard, the state called a witness and a potential co-defendant of the accused. The witness claimed the privilege on direct. The state offered the witness immunity. The witness ultimately testified, but the trial court severely limited inquiry into the circumstances surrounding the grant of immunity and the reasons that the witness had changed his testimony. While those facts are not directly on point, the court's reasoning regarding the scope of cross-examination is instructive, especially the court's seemingly interchangeable use of the terms credibility, believability, bias, interest, and motivation. The court reasoned, cross-examination is the principal means by which the believability of a witness and the truth of his testimony are tested. There are few subjects, perhaps, upon which the Supreme Court and other courts have been more nearly unanimous than in their expressions of belief that the right of confrontation and cross-examination is an essential and fundamental requirement for the kind of fair trial which is this country's constitutional goal. The right to test the believability of a witness on cross-examination includes the right to show a witness's possible bias or interest. The exposure of a witness's motivation in testifying is a proper and important function of the constitutionally protected right of cross-examination. The scope of cross-examination as to credibility is and must be broad if it is to fulfill its designated purpose of exposing bias and purging testimony of intended or unintended error. Full exposure of a witness's bias or prejudice is essential if a jury is to be able to fully assess the existence and extent of the witness's bias. The granting of immunity often raises serious problems as to the credibility of a witness. Hoover versus the State of Maryland makes clear that mere knowledge that a witness has been granted immunity does not provide the jury with sufficient knowledge to assess a witness's bias. The likelihood that a prosecution witness is shading or even contriving testimony adverse to the defendant reasonably can be viewed as directly correlated with the perceived value of such testimony to the witness. Thus, in Utah, it appears that bias, prejudice, motive to misrepresent, as well as credibility are not collateral matters. In the instant case, the witness's other crimes relate to general credibility in that all involve acts of dishonesty or false statement. The witness's exercise of the privilege not to answer questions relating to his own believability would violate the defendant's right to confront and cross-examine his accuser. However, the witness's other crimes also relate to the witness's bias and motive to misrepresent, issues which are clearly not collateral, both in Utah and in the federal courts. At the time the witness approached the state with information related to this case, the witness knew that authorities were aware of his Rolex watch scheme, police having searched the witness's home and recovered evidence of the scheme months earlier. In addition, the witness discussed steroid distribution and prescription fraud openly on a jail telephone that was monitored by police. With this knowledge, the witness had a strong motivation to become valuable to the state. Having information related to a high-profile murder case accomplished this. In the witness's own words on the telephone, they, referring to the prosecuting attorneys, need me. Whether correctly or incorrectly, the witness believed himself so valuable that he might be given a pass as to ongoing criminal activity, or at least that's the theory that cross-examination would seek to elicit. This attitude is evidenced by his discussion of criminal activity with his wife on a monitored jail telephone. The witness's motivation to become valuable to the prosecution team in this case is evidence not only of the witness's general credibility, but evidence that he might be lying right now in this proceeding due to that motivation. Thus, in my view, the other crimes of the witness go not only to general credibility, but also to bias and motive to misrepresent, issues which are clearly not collateral. For these reasons, the court grants the defendant's motion to strike the testimony of Jason Poirier. However, should the state elect to grant immunity to Poirier for the other crimes, he would have no privilege against self-incrimination, and this order striking his testimony would be vacated, given that he would be fully available for cross-examination. Do you need time with Mr. Poirier to...
If I could make a record and then just take a few minutes with him, Your Honor.
Go ahead.
We have prepared in anticipation of this ruling possibly coming down from the court, a grant of use immunity, which gives Mr. Poirier immunity for anything that he may testify in court today about these alleged criminal activity. I think it's important to note that it's not full immunity, Your Honor. It's for his testimony today. The bounds would be crossed with respect to any testimony or something that he might offer voluntarily. So if he answers the questions from counsel on both sides, he has immunity for anything that he may say today with respect to criminal activity.
This is use immunity, right? So in effect, all answers to questions are in effect placed into a box, and that box is sealed, but if the state is able to make its case based on independent evidence, that may occur.
That would be correct. Can I just read the court the language?
Go ahead. Mr. Poirier, I want you to listen carefully to this. Go ahead.
And this has been signed off by the County Attorney Tim Taylor, who is also present, Your Honor. Comes now Timothy L. Taylor, County Attorney for Utah County, State of Utah, pursuant to Utah Code Section 77-22B-1, and does hereby grant use immunity to Jason M. Poirier of... What city do you reside in, Jason?
Right now,
Holiday? Holiday, Utah. Date of birth 6/1/1986. Hereafter grantee for testimony given in the jury trial on the above captioned case currently scheduled for October 15th, 2013 to November 15th, 2013, relating to the matter of Martin Joseph MacNeill, wherein defendant is charged with the murder of his wife Michelle MacNeill, a first-degree felony, and obstructing justice, a second-degree felony. This grant of immunity is limited as follows. Testimony, evidence, or information compelled by this grant of use immunity will not be used against the grantee in any criminal or quasi-criminal case, nor any information directly or indirectly derived from this testimony, evidence, or information, unless the testimony, evidence, or information is volunteered by the grantee or is otherwise not responsive to a question. This immunity does not extend to prosecution or punishment for perjury or giving a false statement in connection with any testimony. It's dated the 6th of November, 2013 by Utah County and signed by Utah County Attorney Timothy L. Taylor.
Thank you. Based on that grant of immunity, the court's order striking the direct testimony of Mr. Poirier is vacated. He is fully available for cross-examination. Ms. Gonzalez, do you need time to speak with your client regarding that? Very good.
I can submit this to the court, Your Honor, and receive 3 copies for the parties as well as Ms. Gonzalez.
I will. Thank you. Court's in recess for just a few minutes. Let me know when you're ready, and then we'll begin.
All rise.
Thank you very much. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. Mr. MacNeill is present with his counsel. The state's attorneys are here. Who will you call first today?
The state calls Jason Poirier first.
Very good. Ms. Gonzalez, do you need any more time with your client?
No, Your Honor, Mr. Poirier is ready.
Very good. Let's have the jury in.
Just before they come in, would you just clarify for me so I don't make a misstatement in relation to your ruling about bringing up the guns that were seized in the December 11th from 2012?
Yeah, the nature of the probation violation is immaterial, so no guns or knives will be discussed, just that he was facing probation violations were alleged against him. They were serious and not of a non-technical nature. And if Mr. Poirier says, no, they weren't serious, then you could certainly say, well, you were possessing weapons in violation of your probation. But if he concedes that, yeah, they were serious violations, I don't think what they were matters.
Okay, and even though it may relate to potential charges in relation to the guns?
That's correct. That's correct. On that score, what matters is that he was facing the one-year recommendation, is what gives him the motivation. That's the basis for that ruling. Good morning. Thank you. Please be seated. We are on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are present. The jury is seated. The state may call its next witness.
State calls Jason Poirier.
Mr. Poirier, if you would come forward here to the clerk's desk, please raise your right hand and take an oath.
You do solemnly swear the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. Please be seated here.
Morning, Mr. Poirier. Will you, if you need to, will you correct my pronunciation of your last name, but will you state your name and spell your name for the record, please?
Jason Maurice Poirier.
Will you spell that?
Poirier.
Thank you. And I'm going to ask you to speak into the microphone nice and clearly.
Okay.
Do you know Martin MacNeill?
Yes, I do.
How do you know him?
I was incarcerated with him
When was that?
back in December 2012.
Okay. And where were you incarcerated?
I was in Sundance 1, no,
Okay.
3.
Let me clarify. What facility?
Oh, Utah County
Utah County Jail?
Jail.
Okay. Now, in Sundance, I'm sorry, which one did you say?
Sundance 3.
Okay, Sundance 3, what does that mean?
It's just a separate jailhouse unit.
Okay, so within the jail, they have separate units?
Right.
And one of them is named Sundance 3, that's where you were, is that correct?
Yes.
Okay. Was Mr. MacNeill also in that unit?
Yes, sir.
How did you come to know him besides being in jail?
He was a trustee in that pod,
Okay.
and we came to talking.
Okay. Did you ever, what are some of the subjects you talked to him about? Let me ask you this.
Sorry.
Did you know his profession? Did you ever come to learn about what he did?
Yes,
What was that?
he was a doctor.
How did you learn about that?
I would complain to the nursing staff and the jail staff about my wrist,
Okay.
and they couldn't do anything about it, and nobody would tell me what was wrong with my wrist, and he examined my wrist and told me I had carpal tunnel.
Okay. And so, did he also tell you that he was a doctor at that time, or
Yeah.
why did you talk to him about it?
Yeah, once I said, "What, are you a doctor or something?" And he's like, "Yep, I am."
Okay. And did he help you out with your wrist?
Yes.
Did he give you advice that worked for you?
Yeah, he said just to quit doing push-ups and stuff like that and lay off it.
Okay.
The inflammation should go away.
What were other points of contact between you and Mr. MacNeill?
Giving out clothes, commissary, another conversation struck out about his shoes that he wears.
Let me ask you about, before we go to that, let me ask you about, did you do any writing in jail?
Yes, did a lot of poetry.
Do you know whether Mr. MacNeill did any writing?
Yes, he wrote a autobiography about himself.
Okay. How did you know about his writing?
He would sit down at the desk every day and be writing it.
So you'd see him do that?
Yeah.
Did you ever get an opportunity to read that?
Yes, I did.
How did that come about?
I would have him read my poetry. He would correct it and give me some advice on how to make it better. And then he shared his stories with me and his poetry as well.
Okay. Would you say that you became friendly over time?
Yes, we did.
Let me ask you, when were you booked in?
December 10th, 2012.
Okay, and so how long did it take for you and Mr. MacNeill to kind of strike up this relationship?
First 2 days I was there.
Okay. How long before you were exchanging writings?
That was a good 5 days, to a week.
Okay. Before meeting Mr. MacNeill at the jail, did you know who he was?
I did not.
Had you heard about him before?
I did not.
Okay. If you'll tell us briefly, why were you in jail at that time?
I was looking on some, what do you call it? Violation of probation charges
Okay.
and some theft charges. Those are the theft charges I picked up.
Okay. The theft charge, when you were charged with it, was it charged as a felony?
Yes, it was.
Okay. Have you been convicted of any felonies?
No.
Okay, you mentioned that you had a conversation with Martin about his shoes.
Yes, I did. Sorry, I need to get some water.
No, that's okay. Do you recall when that conversation happened?
I believe it was probably December 14th.
Okay.
It's early in the morning.
Okay. Was it relatively soon, or had you been after being booked in, or had you been there for a while?
I was booked in. I was in intake for 3 days. I think that's the time that they released me into Sundance 3.
Okay. If before you told investigators it was December 17th, does that sound, today you're saying December 14th.
I can't recall what date it was. I can't. It's been a year.
Okay.
It's around that time, December 14th, December 17th.
Okay. Okay. How did the conversation start?
He seemed like he was pretty privileged, especially as a trustee.
Okay.
He had different shoes on and stuff like that, and I just kind of cracked a joke to him saying, can I get a pair of those shoes? And
Okay. And when you say different shoes on, are there jail-issued standard shoes that everybody gets?
no, these were like,
No, let me ask you, generally,
oh yeah,
the jail population, do they all get
they all get
similar
standard shoes.
Okay. And tell me about Martin's shoes.
They were specially made, I guess.
Okay, different from
Dr.
everybody
Scholl's
else's?
or something,
Or were they different from everybody else's?
yes,
Okay, so you were asking, how do I get a pair of those, kind of
Yes.
as a joke?
yes.
What did he say?
He said, no, you can't. And I said, well, how do you get away with that? And he's like, I can get away with a lot of things.
What else did he say?
And he goes, for instance, like, I'm getting away with my murder.
Okay, do you recall, okay, did he say anything else about that?
About his wife?
Okay,
Yeah, he's getting away with the murder with his wife.
did he say he murdered his wife?
He didn't say it like that, but he said, I'm getting away with murdering my wife.
Okay. Do you recall telling investigators earlier when you were interviewed about this that he said, well, for instance, I killed my wife, that should say a lot?
Yeah, I do.
Is that substantially similar to what you're saying today?
Yes.
What happened next in that conversation?
I kind of just sat back and kind of chuckled, thinking he was lying.
Okay,
I went back to my cell, got the clothes from him, and went back to my cell.
okay. Did you ever talk to Martin about his wife again?
I did.
Do you remember when it was in relation to the first conversation?
It was just I think it was the next day or a few days later.
Okay, relatively close.
Right. It was back to back. I was in my cell thinking about it.
Okay. How did that conversation start?
I approached him. He was in the cleaning room, cleaning the bucket, the mop bucket. And I just went up to him and said, hey, man, I apologize about your wife. And he goes, oh, no, I'm glad the bitch is dead.
Okay, will you speak up when you answer?
Yeah, he said, I'm glad the bitch is dead.
Okay.
Sorry for my language.
What happened in the conversation after that?
I proceeded to go back to my cell and clean my cell.
You didn't carry on any conversation for?
No. After that, I was pretty shocked.
Okay. Did you ask Martin about his wife anymore after that?
That was when we started doing the poetry and stuff like that. I sat down next to him, showing him poetry. And we started talking. I read his autobiography and his life story, somewhat of it.
Did Martin talk to you at all about the relationship he had with his wife before she died?
A little bit, yes.
Do you recall what he said?
That it was going downhill, that they're trying to get his money, and that she was not going to let him keep cheating on her.
Okay.
She wasn't going to allow that.
Did he say whether he actually was cheating on her?
Oh yeah, he told me about his girlfriend.
Okay. Did he tell you what his girlfriend's name was?
I don't remember. I don't recall.
You don't recall whether he told you, or you don't, or he?
I don't
told you
recall
and
the
don't know
name.
What it was?
I don't recall her name.
But did he tell you?
Yes.
Okay. But
He told me about the trip and everything they've taken
what trip?
up into the ski resort.
Okay. Let me ask you, did he tell you when that trip to the ski resort occurred?
I would assume in winter. He didn't tell me exactly what time he took her up there, but
Okay.
it was after he was released from federal prison for his fraud.
Okay. When he was, okay. Did you ever have a discussion with Martin in the rec yard?
No, he didn't really go out to the rec yard that much.
Okay.
You mean the rec yard or there's two facilities. The rec yard's the outside facility.
Okay. Well, let me ask you this, a more general question. Did you ever have another conversation with Martin MacNeill about his wife that ended your relationship with him?
Oh, yes.
Will you tell us about that?
That was when we were swapping the poetry. And after I was done reading his autobiography, after reading it, And the way we were talking, I figured stuff he was saying. So I asked him, are you serious about this?
About what?
About murdering your wife?
What did he say?
And he goes, yes, I'm serious. Look where I'm at. He threw up his arms and said, look where I'm at.
Okay. If I told you that you told investigators earlier that he said that you asked him if he was joking about this stuff, and he said, look where I'm at, does it look like I'm joking? Is this the same conversation you're describing now?
Yes, that's the same conversation.
How did you react to that?
At that point, I believed him that it was what he was saying, and I immediately told the guards I needed to switch sections.
Why was that?
I didn't want to be around him.
Okay. I'll tender the witness at this point, Your Honor.
You may cross.
Does your memory get better with time?
Nope, I'll get older.
You've given an interview with investigators in this case, correct?
Yes.
And that was on January 31st of 2013.
Yes.
You attempted to be truthful in that interview?
I was truthful.
Truthfulness isn't your strong suit, though, is it?
Yes, it is.
It is? Okay. Going back to January of 2012, you went into a Walmart store, correct?
Yes, I did.
And you reached into a display counter and removed a laptop computer?
Yes, I did.
And then you went to another part of the store and concealed that underneath your shirt?
Yes, I did.
And then you left the Walmart store without paying for it, right?
Yes, I did.
You were subsequently approached by police, correct?
Yes, I did.
You lied to police, right?
Yes, I did.
Told them that you didn't remove the laptop?
Yes, I did.
That you you left it in the store somewhere after they saw you on the surveillance video removing it out of the counter. You said you left it someplace else in the store, right?
That's correct.
You were arrested
That's correct.
and taken to jail, correct?
Yep.
You wrote a letter to Judge McVeigh, who was assigned to your case, correct?
Correct.
That letter was dated January 24th of 2012?
I'm not sure. It could be.
That was about the time that you were arrested, right?
Yes.
In that letter, you put to Judge McVeigh that the worst part about being in jail is not being able to be with my little girl, or I'm sorry, not be able to watch my little girl grow up, correct?
Correct.
And you put, I don't want to miss it, correct?
Correct.
My wife is struggling and it kills me to be away and put my family through this.
Yes.
I have failed my wife, child, myself, as well as society, right?
Yes.
I've never been away from my family like this. That's what
Yes.
you said, right? I heard you offer last chance probation.
Yes.
I know my matrix is not that high, but I'm willing to show you I can complete probation. If you give any chances I'm the one who will take the chance and not waste it for my little girl's sake and families.
Yes.
And then you said, I'm serving 6-month sentence for catching the theft charge while being on probation for almost 2 years.
Yes.
So when you were taken to jail, you were actually ordered to serve a 6-month sentence for a probation violation.
Yes.
Right? You hadn't actually been sentenced yet on the shoplifting charge.
No, I haven't.
You went on to tell Judge McVeigh that you will not let him down. I know where I will end up if I do.
Yes.
I don't want to lose my wife and ruin my family over the poor choices I have made.
Correct.
That's what you said, right? And this was all in January, your January 2012 letter, right?
Yep.
And you proceeded to serve the 6 months on your probation violation, correct?
Correct.
In the summertime, you were out of jail, right?
Correct.
You continued to operate a scheme which you had done in the past in relation to selling fake Rolex watches, correct?
That's not correct.
It's not correct?
No.
You didn't sell
When I was
fake
released,
Rolex
no, I
watches?
did not.
What?
You said after I was released that I
Yes.
continued to do that? No, I did not.
You'd only done that in the past?
Yes.
You don't remember in July of 2012 being approached by a person that said that you'd sold him a fake Rolex watch?
July?
Yeah,
12?
July of 2012. And then you told that person that no, you hadn't, and that your aunt was a member of the Lehigh Police Department?
I remember saying that, but that was not after I was released this last time. Is that what you're referring to?
It was in July of 2012, wasn't it?
Oh, 12, yes, I did.
Yeah.
You just said when I was released this last time. That was in 13.
Okay, if I've said that, pardon me, I thought what I said was that when you were released from serving the probation violation that you went into custody for in January of 2012.
Yes, but that letter I wrote was my last incarceration.
It was in January of 2012.
Right.
Right? And so then you served the probation violation at that time, and you were released and you were out in the summer of 2012, right?
Right.
And so then in July of 2012, you had sold a fake Rolex watch to an individual, right?
Yes.
And then that individual caught you, and you attempted to dissuade him from doing anything about it, and said that your aunt worked for the Lehigh Police Department, right?
Correct.
And you even gave a name of who your aunt was, right?
Right.
And the name you gave was your probation officer, Tammy Black.
Right.
Right? That was all a lie, of course, right?
Yes, it was.
Tammy Black is not your aunt.
No, she's not.
And you had even texted that information to this person that you sold the fake Rolex watch to.
I did.
You sold a number of fake Rolex watches to people, right?
No, it was only just that one. I had quite a bit of them, though.
That was the only one that you sold?
I sold, I think, about 3 total.
Those are at least the 3 that people reported, right?
Yes.
You sold more than that, though, that didn't get reported by people, right?
Yes.
And then in November of 2012, strike that. So very soon after you're released from serving your probation violation, contrary to your letter to Judge McVeigh, you're engaging in deceptive criminal activity again, correct?
Correct.
And then in November of 2012, you go into a Cabela's store in Lehigh, correct?
Correct.
And you buy some things, correct?
Yep.
And you conceal some ammunition in a sweater that you had in the cart,
Correct.
right? And so you stole the ammunition,
I did.
right? And you got caught.
I did.
That case was also assigned to Judge McVeigh, wasn't it?
Yes.
And then on December 10th of 2012, you appeared before Judge McVeigh both on the Walmart shoplifting case and new felony charges on the Cabela shoplifting case, right?
Yes.
The Walmart case was also a felony. It was charged as a felony, right?
Yes, it was enhanced because of my priors.
So because of prior theft charges.
Right.
And so on December 10th of 2012, you were able to negotiate a deal with the prosecutors on the Walmart case, and it was reduced to a Class A misdemeanor.
Correct.
And in fact, when you were arrested on the Walmart case, after you'd lied to the police officers about what you did, you even asked the police officers if the prosecutors are generally willing to cut deals for felonies, didn't you?
I don't recall.
May I approach right?
You may.
Showing you the police report from the Walmart case, does that refresh your recollection about your conversation on the way to the jail?
That's what he's saying.
Is that not what you said?
I don't recall.
And so you enter a plea on December 10th, 2012 on the the retail theft charge. You're not in custody on that day, though, right?
No.
December 10th? And then,
December 10th, I was in custody. December 10th, 2012, I was arrested and booked.
not at the time that you appeared in court, though.
No, that was the December 9th.
If I show you a court docket, think that may refresh your recollection?
Yeah, that would. And that letter to Judge McVeigh, I believe, was actually the letter I wrote while I was incarcerated December 10th, 2012.
Oh, okay, well, let me show you that one, too.
Because that's why I was asking him for last chance probation, because he knew of all these cases I had.
Let's see.
Go ahead. Yeah.
So first, this letter, it shows a court stamp of January 24th, 2012, right? Do you think that was actually in 2013?
Yes,
You sure about that?
because he was aware of all my charges combined,
Okay,
and that's why I was asking for last chance probation.
okay. What? Does this appear to be the docket of the criminal case in relation to the shoplifting for which you entered a plea on December 10th of 2012? You're advised of your rights. Sentencing was set for January 7th of 2013.
Yes,
Does that refresh your recollection?
yes,
So it was actually December 10th of 2012 that you appeared in court and entered a plea on the Walmart shoplifting case, right?
right, correct,
And you also had your first appearance on the Cabela's shoplifting case.
Correct.
Right? Which was charged as a felony.
right. And that's why I wrote that letter to Judge McVeigh.
And so this, you think, was actually January 24th of 2013?
I know it was.
Okay. And so after you enter your plea on December 10th of 2012, and then also enter a not guilty plea on the Cabela's charge, you went home, right?
No, I was incarcerated.
Well, on the 10th, you weren't incarcerated, right?
Yes,
Because, well, it wasn't until your probation officer and police officers came to your
Violated
house
me, yes.
afterwards.
they violated me because I pled guilty to those, yes.
Yeah, but you came to court on your own, right?
Yes, I would,
And then you went home, right?
right,
And your probation officer called you, right?
yes,
And you lied to her, right?
I did,
You told her that you were in Bountiful,
I did,
right? You told her that you were working on a construction job,
I did,
right? And you told her that you were driving a truck initially.
Nissan Xterra,
And then you later corrected it that the truck was the Xterra, which your probation officer knew that you drove, right?
exactly,
You were really standing in the backyard of your house while your probation officer was out in the front of your house, right?
I did,
And your probation officer then told you that she knew where you were, right?
yes,
And then you were taken into custody at that point, right?
yes,
And then your house was searched, right?
correct,
And they found numerous items of Rolex, fake Rolex paraphernalia,
correct,
right? Found other issues that led to a serious probation violation,
correct,
correct? And then you were taken to jail,
Correct.
And you were placed in classification,
Correct.
right? And you didn't, and classification is an area where you're separated from the regular population, correct?
Yes.
And you were released from the classification area on December 14th of 2012, right?
I would assume so.
That sounds about right, right?
Right.
And so it was on December 14th of 2012 that you went into the Sundance 3 that you've testified to, right?
Correct.
And that would have been the first time that you would have had any opportunity to meet my client, Mr. MacNeill.
That's correct.
And you you testified or stated in your interview with it was Investigator Robinson that interviewed you on January 31st of 2013, right?
Correct. And
in that interview, you told him that it was on December 17th, 2012, that Mr. MacNeill allegedly told you that he had killed his wife, right?
I would assume it was December 17th.
And so it was just 3 days after you went into population, right?
Correct.
And then you told him in that interview that that 2 days later, on December 19th, that you went up and talked to him again, not thinking that what he had allegedly told you on the 17th was real.
Right, I thought it was a joke.
Yeah, and then
Inmates joke all the time.
What's that?
Inmates joke all the time.
And then and on that second discussion on December 19th of 2012, you said that that's when he told you that I'm glad the bitch is dead, right?
Exactly.
And then you told Investigator Robinson that that's the last time that you talked to him about it in your interview on January 31st of 2013.
I don't recall that. I remember 3 vivid conversations.
Okay, we'll get to that. And in your interview, though, you didn't discuss any other conversations other than those about allegedly Mr. MacNeill harming his wife, though. Isn't that correct?
Correct.
You knew when you were in custody that your circumstances were serious, right?
Yes.
You knew that your probation officer was very upset at you.
It varies.
And you knew that you had a felony case pending from the Cabela's theft, right?
Correct.
You knew that you had the Class A misdemeanor case pending for the Walmart theft, right?
Correct.
And you were again in December of 2012 violated on your past probation, correct?
Correct.
And so you were given a 6-month sentence in relation to probation violations, which began on about December 14th of 2012.
Correct.
And so in addition to that 6-month sentence on the probation violation, you were facing 1 year on the Walmart case and then 0 to 5 years in prison on the Cabela's felony case.
Correct.
Right? And in relation to the search of your house on the day that you were arrested, you also knew that you were likely facing charges in relation to the Rolex watch scheme.
Correct.
And other issues.
Correct.
Correct. And you knew that those other issues were serious, didn't you?
I knew they were serious, but I've seen people with worse cases than mine not face what they were actually facing.
Sure.
I knew my max would probably have been a full year.
That's just on the Walmart case. Your maximum sentence was a year, right?
Right.
And while you were incarcerated, you had a number of phone conversations with your wife, correct?
I did.
And in those phone conversations, you discussed other criminal activities that you were engaging in, correct?
Correct.
One was Dr. Moore. It will involve Dr. Moore, correct?
Correct.
And in your phone conversations with your wife, you instructed her in December of 2012 to lie to Dr. Moore about where you were so that she could get medications from Dr. Moore to sell.
To obtain my medications,
To obtain
yes.
your meds, yes. And your wife was selling your medications, right?
Correct.
And you'd instructed her to do that, right?
Correct.
You told her that she didn't have to work, that she could just use the shit from Dr. Moore, right?
Correct.
And you also had discussions with your wife about your landlord, right?
Correct.
And you instructed your wife to lie to your landlord, correct?
Correct.
You told your wife that she should go to the landlord and say, hey, we want to buy the house, we just need 2 months, and then you told your wife that you just get the landlord to agree to that, and then when you get out, you'll just move out.
Correct.
That's what you told her.
Yes. We also,
Knowing that would defraud the landlord, right?
well, he defrauded us at first as well,
Okay.
with mold in the house.
Oh, okay. After what you represented to be the December 17th and December 19th discussions with Mr. MacNeill, you continued to be very friendly with Mr. MacNeill, correct?
I did.
And you purchased commissary items from him, correct?
I did.
And you had to do that because any money that was put on your books at the jail would be taken by the jail, and so you couldn't use your money to buy commissary yourself.
Correct.
Right.
Inmates with misdemeanors cannot obtain commissary.
Right. And so you had Christina multiple times put money on Mr. MacNeill's books so that then you could use that for your own commissary.
Correct.
Right. And then you also had your wife send you care packages,
Correct.
correct? And there was a care package that was sent at the end of December that you didn't get everything from Mr. MacNeill that you thought he should have given you, right?
I got everything.
You don't remember telling your wife that you didn't get everything?
I did say that to her, but after reading the paper, it said that there was a max spending limit that he could only spend. So I was, items were taken off that were not paid for, and my wife was reimbursed the money.
So you admit that in the phone conversation it says that Mr. MacNeill didn't give you everything that he was supposed to, but you said it was subsequently resolved?
Yes.
Okay. You went to court on January 7th of 2013, right?
Yes.
And on that day, you found the recommendation from your probation officer, well, you found out about the recommendation from your probation officer in relation to sentencing on the Walmart theft case, right?
Correct.
And she had recommended a year in jail to run consecutive to the probation violation.
Correct.
Right? And you were also informed that the prosecution was not going to reduce the felony charge on the Cabela's case, right?
I believe they were going to run them all concurrent, though, for 1 year.
So you believe that they would run them concurrent, but they were not.
I believe that
going to-
was the deal.
Yeah, and that's pretty much what you told your wife, is that they would run the felony charge concurrent, but they would not reduce the felony charge for purposes of entry of plea.
Correct.
Right. You were worried you were going to go to prison, weren't you?
No, was not.
You believe that your probation officer, Tammy, was going to recommend prison.
No. I was not aware of that.
You don't recall telling your wife, Christina, that your probation officer was going to recommend prison, but you didn't think that the prosecutor was going to go along with it?
She may have wanted to recommend it. I don't remember her recommendation. But I do remember the prosecuting attorney's recommendation that it was not going to be prison. There would be a year's consecutive with good time, so I'd serve a full year.
Okay.
So I knew the max I was looking at was a full year.
Okay. And then on January 8th, you had a conversation with your wife where you told her that you had some good news for her, right?
I did.
And you told her that you and your attorney Barbara were working on this thing, right?
She was working on another case for me, working on my case.
And that this thing that you and Barbara were working on had to do with giving information to the prosecution about Mr. MacNeill.
She said she'd pass that along. But that's all she could do.
And you told your wife that was going to, well, you told her it was going to be really good news, didn't you?
I did.
And in relation to what Tammy was recommending, you told your wife that even though Tammy was recommending prison, the prosecutor said he doesn't give a F what Tammy says. This is his first felony. We're not going to send him to prison on his first felony. That's what you told your wife, huh?
Yes. I don't think Tammy requested prison. I'd have to see her recommendation.
Well, she hadn't actually given a recommendation on the felony charge yet, right?
Her recommendation for both cases were the year statute. I don't recall her recommending prison.
Or push on her?
You may.
Unless you hold this. Did you look at line 358 and 359?
This is a conversation with my wife,
Yeah.
not Tammy's recommendation, right?
Doesn't that refresh your recollection that you told
It
your
does.
wife that Tammy wanted to send you to prison on the felony third? That's what a recommendation is?
That's just what I was assuming she would do,
Okay.
but that wasn't her recommendation.
But that's what you believed Tammy was going to do is recommend prison on the felony third, right?
Yes, but I also knew that what the prosecuting attorney was going to go
Because the prosecutor didn't give a F what Tammy said, right? That's what you told your wife.
Yes.
You had a number of conversations in January of 2013 with your wife about what you were going to get from giving information to the prosecutors about Mr. MacNeill, right?
Sure.
And you believe that you were going to get a substantial benefit conferred upon you in exchange for the information that you gave the prosecutors, right?
Yes, I believed that my charges would all be dismissed and I would be released.
That's what you thought would happen, right?
That's what I thought would happen.
And you discussed that with your wife multiple times.
Correct.
You also had discussions with your wife about an occasion in the past where you tried to be an informant, right?
Correct.
and that it didn't work in the last case because you'd already been sentenced, right?
Correct, but I was still willing to testify.
And in this case, you told your wife that it could work because you haven't been sentenced yet, right?
I don't recall. That's too long ago.
Okay. And then on January 24th of 2013, you talked to your wife and told her that you're just going to be blunt, that you're probably going to do a full year,
Correct.
right? And then on January 25th, 2013, you told your wife that you got some good news, that your attorney Barbara came down to the jail and told you that things are looking really good, she's going to get you out.
Not get me out.
You turn to page 25 and
Release me on GPS.
yeah, see page or line 701. Well, maybe start on 695. You told your wife that you've got some good news, right?
Yep.
And then you said Barbara came to see me today.
And Barbara is going to try to get me out now.
In 699, and it looks like with that situation is referring to you giving information about Mr. MacNeill, right?
699?
Yes. May I approach?
No, I believe she was doing something with running my cases concurrent,
Yes, you may.
trying out GPS.
Yep.
Yeah, I am. 25.
Yeah, okay. So you see line 699, and you said, and looks like with that situation,
Of running my,
okay, that situation is you giving information about Mr. MacNeill, right?
I believe at that time, I believed Barbara was just running my situations concurrent. I assumed.
Okay, well, look at line 701 then.
I believe
Line
McVeigh
7,
got my letter.
on line 701, you said, she's going to get me out. Right?
Right, on GPS, after I served the 90 days.
Well, actually, on 701, you said, she's going to get me out. And then on 703, you said, I was like, what about GPS? And she was like, I can get better than that, where I don't even have GPS. That's what you said, right?
Yes.
And then down on line 713, you told your wife she doesn't even need to worry about going to court on Monday. And on 7, right? That's what you said?
Yes, I did.
And then on 715, you said she doesn't because they are postponing it because they are doing that thing for me. Barbara is going to try and get me, you know. That's what you said, right?
I did.
Then down on on the next page, 26, you say, yeah, so I was excited that happened because I was really thinking I was going to be here, and she came and saw me and said, I figured I should come and see you because last time we talked I told you to brace yourself for a year, and I wanted to break the good news to you in person. That's what you told your wife about
Yes.
what Barbara said, huh?
Yes.
Then on line 36, you were talking to your little girl, and you said, I'm coming home, sweetie pie. Right?
Yes.
Then down on line 740, you said, baby Barbara is very, very confident And I was like, just GPS? And she said, I don't think you're going to get GPS because that's too expensive. Worst case scenario, you do get GPS, blah, blah, blah. That's what you told your wife, right?
Yes.
So then on January 31st, you had another conversation with your wife, right?
Correct.
And that was the same day that you had your interview with Investigator Robinson, correct?
I did.
And so you call your wife and you tell her, I've got some good news for you, right?
Yes.
See that on line 747?
Yes, I actually remember this conversation.
Yeah, okay. And you said, really, really good news, right?
Yep.
And Barbara came down, right?
Right.
Barbara thinks she can get me out, line 767. Barbara thinks that she can get me out without even GPS.
Correct.
777, he said, baby, I would not be calling and telling you it unless I knew 100% for certain.
Correct.
Right? Last time I called you, I said, that's just what Barbara said she could try to do. Now it's 100%, because the prosecuting attorney has agreed to it. Correct?
Correct.
There was actually a prosecuting attorney that was present in that interview with Investigator Robinson as well. Correct?
Correct.
So the prosecuting attorney agreed to the deal that you wanted after that interview. Is that
Not
right?
that I wanted, no.
What did he agree to?
He agreed to help me out a little bit
And
with what I knew.
what's that?
He agreed to help me out with a little bit with what I knew.
And what was the help that you anticipated?
I wanted to have my record expunged. I figured with what I knew that I could help out. And then when they said they can only help out a little bit, I said, well, I still want to do this.
And so what was the help that you expected them to give you?
I expected them to exonerate my criminal record and not serve any time, but that's not what they agreed upon.
Okay. And you told your wife in that same conversation on January 31st, he says, listen carefully, I can say it right now, just, they need me. That's what you told her, right?
Correct?
And you'd previously told your wife, even before you had the interview with the prosecutors, that this is big, I'm going to be on TV.
I don't recall saying that. I said I could be on TV.
You could be on TV. Okay.
I didn't know the full extent of this.
Okay. So you continued to talk to your wife, correct, on the telephone?
Yes.
And then you had a number of conversations with your wife about distributing steroids, correct?
I did.
And you sent even some of your friends that have been in jail to meet up with your wife to buy steroids that were yours, right?
Correct.
You instructed your wife on how much she should charge, what she should sell as well, correct?
Correct.
Your wife also started selling, in addition to your drugs, she also started selling some of your equipment, correct?
What,
Objection.
define equipment.
Some of your
sorry?
possessions?
Relevance objection, Your Honor, I'm not sure it matters what his wife was doing.
He had instructed her.
Do we have that established?
Yeah, does it, will you approach counsel? Objections overruled.
So you'd instructed your wife to start selling some of your other possessions, correct?
Correct.
And she was selling them with an agreement on at least some of them that once you got out of jail, you'd be able to buy it back, from your friends, right?
The only things they sold was to my landlord for rent.
What's that?
The only things I can recall that she sold was items to pay for rent. And then he made a contract I could get them back if I chose to.
She sold things like your nail
Air
gun?
compressor, nail gun, stuff like that.
In exchange for your testimony here today, you've been granted immunity, correct?
Correct.
And so the prosecution can't use any of your admissions today against you in prosecutions, right?
Correct.
So they can't use your admissions to prosecute you in relation to the Rolex watches, right?
Correct.
Can't use your admissions to prosecute you in relation to distributing Dr. Moore's
Correct.
drugs, right? Can't use your admissions today to prosecute you for distributing steroids.
Correct.
And you knew as you were in jail that all of your phone calls were being recorded, right?
Correct.
And so you knew that the prosecution, at least at some point, you knew that the prosecution had some pretty good evidence about criminal activity that you've been involved in, right?
Correct.
And you obviously also knew that you were facing some pretty serious consequences in relation to the probation violations and other pending charges as well, correct?
Correct.
Back to your interview on January 31st with Investigator Robinson. Got a little copy of that on here for you. There it is. May I push on?
You may.
Copy of that transcript. So in your interview on page 1, if you'd read just to yourself lines 25 through 30.
$25 through $30.
Yes. Got it? So this is the very first part of your interview, correct?
Correct.
And so Investigator Robinson, he tells you, he says, we recognize that part of your motivation for making a statement is based on wanting some leniency from the prosecutor in your cases. That was correct, right?
Correct.
And he said, I can't speak for the prosecutor, but we do have a prosecutor here to observe you when you make your statement, right?
Yes.
And you can make decisions about your case depending upon, let's see, and who can make, in other words, the prosecutor, who can make decisions about your case depending on how we feel about the things after this meeting and communicate with Ms. Gonzalez, your attorney, right?
Yes.
So Investigator Robinson told you at the beginning of your interview that the amount of leniency that you may get depends upon how they feel about the information you provide, right?
Not the amount. I don't
The
believe,
amount,
I
just
don't
the
believe he admitted or said something like that.
Well, he says the prosecutor can
I
make
misunderstood you. I thought you said that I would receive some leniency. I don't think they had a wide range of what they could do.
It says the prosecutor can make decisions about your case depending on how we feel about the things after this meeting,
Yes.
right? That's what they told you.
Right.
And then on the next page, on page 2, you told them that what you heard shocked you really bad, right?
Yes, it did.
But what you heard was on December 17th and December 19th, right?
Right.
And so after you were allegedly shocked really bad, you continued to have lots of interaction with Mr. MacNeill, as you've described, shared poetry, read his autobiography. Of all the people in the jail, you chose him to have your wife put money on his books to help you with commissary.
Correct.
Right?
Correct. I was still in the pod. The transferring pods was not instant.
And so, and as we discussed, you didn't get into the area where he was until December 14th.
Correct.
Right? And so then if you look on line 54, let's see, maybe starting up on 48, what you told the investigators on January 31st is that I walked up to him and said, "Hey, Mac, you know, we introduced each other, but this is after a few days of talking to each other, so December 14th to December 17th, right? Right? Mr. Poirier?
Yes, I'm reading this.
Okay. So what you're saying in line 48 is that you went up and you introduced to each other, and this is after a few days of talking with him, right?
I believe it was a few days, but
Yeah, so it puts us to December 17th, right?
yes, but he has actually said a few things by then.
Oh, even before then?
Before then, yes.
Okay. And I walked up to him, got some food from him. He was talking to me, and I go, "Hey, you know, why do you get to wear those shoes?" And he says, "'Cause I got a lot of issues, and I can get away with things in here." That's what you testified to, right?
Correct.
And you said, "What kind of issues?" And then you said, "What really shocked me that day was," he goes, "well, like, for instance, I killed my wife."
Correct.
Right? And then you go on and in line, or in paragraph 54, and you say, that should say a lot. Well, I'm sorry, that's continuing on from what you said. "Well, like, for instance, I killed my wife, that should say a lot." And then you say, "I didn't know how to react to that, so I went back to my cell, thought about it, and wrote it down," and that was December 17th, right?
That's what I wrote down. That's what the day it was.
And it was right after cleaning our cells, so it was December 19th when I went up to him and asked him again. I believe it was December 19th. It was December 19th for sure, you said, right?
That's what it was that day. Yes.
I walked up to him and asked him, "Martin, you know, what's going on with what's going on with you?" And it's just really shocking what you said. So I go, "I'm sorry about your wife," and he goes, "Don't worry about it. I'm glad the bitch is dead, plain and simple." Right? That's what you said he said on December 19th.
Correct.
So 5 days after you'd been together in the pod.
Okay.
Right? That's what you testified to on the 31st, right?
Correct.
And then over on page 3, you continue on with that conversation. You say that your brain's flabbergasted right now, right?
Yes.
And then you say, but you don't know too much about all of that. You haven't read newspapers about him, is what you say, right?
Yes, I did not know about Mr. MacNeill.
But by then, you'd already told your wife that this was big and you could be on TV before this interview, right?
Correct.
And so, and this is a continuation of your conversation about December 19th, correct?
Yes.
And so then you say, going on, hey, MacNeill, are you joking about this stuff? And he just throws up his hands and says, look where I'm at. Does it look like I'm joking?
Correct.
And then you say, and that's the last time I talked to him from this case.
Yes.
So in your interview on December 19th, you made it very clear that there were two conversations, one on December 17th and one on December 19th, right?
Correct.
And that's the last time you said on the 31st that you talked with Mr. MacNeill, right?
Yes.
And that's different from your testimony here in court today, right?
I guess, yes.
And you testified here in court today about talking with Mr. MacNeill about his girlfriend, right?
Correct.
That was a girlfriend that he had met after he was released from federal prison, right?
I'm not sure.
And he told you that he met her when they went to...
Objection, hearsay.
He's testified to it on direct exam.
He did. I'll allow it.
And so he told you that he met her after he got out of federal prison, did he not?
I'm not sure.
Okay. The investigators asked you if he ever mentioned an individual by the name of Gypsy, and you said, no, sir, sorry, right?
Yeah, that's correct. The name he gave me was a lady, I would say it started with an M. I'm not sure.
In addition to being granted immunity for the things that you're testifying about here today, you also were given additional consideration in relation to your charges, right?
Can you repeat that?
In addition, maybe that was a long question, I'm sorry if it was confusing. So you've been granted immunity in relation to the testimony that you're giving here today, right?
Correct.
Separate from that, you also were given additional benefits in relation to your pending charges, correct?
Yes, they ran them concurrent.
And so
And the immunity I just found out today.
on June 10th of 2013, you entered a plea on the Cabela's charges, right?
Correct.
And those charges were reduced to a Class A misdemeanor, correct?
Correct.
And you were given court probation on both charges, right? And you were given a nominal fine,
Correct.
right? No jail time.
I did do jail time. 3 months
you
and
did-
4 months on GPS.
That was in relation to the probation violation, right?
No, they run those concurrent with that.
Yeah, you didn't get any additional jail time for the two retail theft charges, right?
Correct.
So they just chalked up what you'd done for your probation violation and called it good.
They do that all the time.
Okay. And at your sentencing hearing or entry of plea, you told the prosecutor that you were currently enrolled at Utah State, correct?
I did. No, I did not say I was enrolled. No, I did not.
You said you were enrolled at Utah State.
No, I said I was going to go to try out for the baseball team for Utah State.
So if the prosecutor has in their notes that you said that you were enrolled at Utah State and on the baseball team, that would be incorrect?
Yeah, that's incorrect. I don't believe I said that I was enrolled. I said I was going to go try out for the baseball team and enroll. That's why we moved out to Logan.
Okay. How old were you in June of 2013?
27.
So you're going to go try out for the Utah State collegiate baseball team
Correct.
at 27. Okay. So in January of 2013, you knew that Tammy, your probation officer, wanted to send you to prison in relation to the felony charge on the Cabela's case.
Objection asked and answered.
Sustained.
In notwithstanding your probation officer's recommendations, in June of 2013, you got an extraordinarily good resolution of your cases, correct?
No.
Asked and answered.
Overruled, he may answer. Go ahead.
I don't believe I got what you say.
You have a lengthy criminal record, right?
Yes?
And you had already had one felony retail theft charge, the Walmart charge, reduced to a Class A misdemeanor in December of
Correct.
2012, right? And so then in June of 2013, you get the second retail theft charge
Correct?
reduced, and you got no formal probation, correct?
Correct.
And you hated probation, didn't you?
Yes, I did.
In fact, you told your wife in one of those phone calls that that you're in December of 2012, into December 2012, about how much you hate probation and you ain't going to do this anymore, right?
Correct. I've been on probation for going on 5 years.
Long time. You said you're sick of it. You're sick of the government interfering with your life and restricting what you could do, right?
I don't recall saying that.
You said that you're tired of having Tammy come and check up on you.
I recall something like that, yes.
And you said you ain't going to do it anymore, right? End of December 2012.
Correct.
In May of 2013, you were released from probation for your older cases, right?
Correct.
And you went on to Facebook and made a posting about that, right?
Correct.
And said that you're all done, right?
Correct. That was after I got released off GPS.
Yeah, he said, I'm finally off GPS after serving 90 days, right?
Correct.
And off probation after 6 long, effed up years,
Correct.
right? Having to be told what to do,
Correct.
right? Got my stuff back from the law.
Correct.
I'm a free man.
Correct.
But you still had 2 pending cases at that time, though, right?
No, they ran those concurrent.
Well, this is in May of 2016, so you hadn't even been sentenced yet.
I knew they were going to run those concurrent.
Yeah, you knew you had a good deal, right? And then you said, anyone who can't congratulate me can F off. F a fake friend.
Objection,
Where-
relevance.
He's expressing his opinions about probation.
Overruled.
Expressing his-
Overruled, he may answer.
Correct.
What you said, right? And so then after that, you go and you get this deal in June of 2013 with your current charges, right?
Due to my matrix, I don't believe I got the deal that I could have.
Okay.
I've seen people with bigger matrix than me do more time
Okay.
or less time.
You sure got a whole lot less than what you thought you were facing on January 7th of 2013, didn't you?
By a couple months, yes.
A couple months? I mean, you were facing prison for what Tammy wanted to recommend anyway, right?
They recommend that stuff all the time. They always recommend statute.
In February of 2013, February 13th of 2013, you had a conversation with your wife, correct?
Correct?
You want to turn to page 33?
This one just goes to 18, is it the other one? That's the test, that's the,
Yep, it's this one. You have a friend named Buddy, right?
correct?
Buddy is one of your friends that was not only buying some of your drugs, but also bought some of your other stuff, right?
Correct?
Buddy wasn't always kind to your wife, right?
Correct.
And so on on February 13th of 2013, you told your wife, I think when I get out, honestly, I'm going to go down there and be friends with him. And him is you're referring to Buddy, right?
Correct.
I'm going down there and be friends with him and be like, hey, did you get my gun and all my stuff like that, my nail gun? I need it for work, blah, blah. And then when he gives it to me, I'm going to go straight to the cops exactly that day and say, hey, I just got this back from him and he burglarized my home. When
That's
I
not
was in
true.
jail with my wife. That's what
not
you
true.
said, right?
No.
Okay.
I said that, but what was in, you're misconstruing everything. When my wife sold some of my tools, there was a few things missing and stolen.
Okay. I'd like to play this phone call. It has obviously some hearsay elements in it, but I believe that it's admissible for foundation purposes for what Mr. Poirier actually said.
Is there a reason to play it beyond just, you just read it, right?
I read part of it, but he's disputing the context, and I think that his actual...
Well, you're saying that I'm telling him he's not the one that bought the stuff like I said. My landlord took my tools.
You can talk next time a question's asked, but see,
go ahead.
there again with that, I think we need to play it so that the context is clear.
I'll receive it to establish context for the statement so that its meaning can be clear.
If I could have my assistant just cue it out so that we're in the right spot with headphones and then in two parts on the same phone call. So,
Before it plays, I'd just like to make a record that this appears to be an incomplete recording of the phone call. There's segments of it, but it doesn't give the entire phone call. Is that right?
I'm happy to play the entire phone call if you'd like.
Well,
The rule of,
I'm not, yeah.
are you, on redirect, you can introduce other parts to give further context under the rule of completion,
No,
so
we just want the record to show that this is not the whole call.
you can establish that on redirect.
Jason, you had 2 of everything, 3 of everything. Down there? And here, other than your air compressor, which is the one and only thing you told me not to sell, which I had to, and we have the option to buy it back. Buddy knows how much we got money.
Buddy's place, huh?
Mm-hmm.
I'm gonna
And I was like, yeah.
I think when I get out, honestly, I'm gonna go down there and just talk to him, be friends with him, and be like, hey, you get my gun and all that stuff like that, my nail gun, I need it for work, and blah, blah, blah. And then when he gives it to me,
Okay.
I'm gonna straight call the cops exactly that day and say, hey, I just got this back from him, and he burglarized my home when I was in jail with my wife, and if you can come down and sign a document and statement against him, I'm getting him thrown in jail for that shit.
Good. Well, and the thing is, she's like, she works from 7 o'clock in the morning till 8 o'clock at night, and he's just like, and he's looking for it, and then Buddy texts him. He's like, I was on my deathbed at the beginning of January. And then Christina, get this. She says, Buddy's car got stolen today. I'm like, of course it did. Of course it did. Like, really, Buddy's car got stolen? Come on.
He's gonna feel how I feel sitting here because the homie just backstabbed. So you know what?
Yeah.
When I get out, I'm gonna go down there and collect my stuff, leave, go straight to the police department, and then you'll be there. Like these guys, I got back from him, but he burglarized my home while I was gone.
That was an accurate representation of your conversation with your wife, right?
Exactly.
So you were going to go get back at your friend Buddy, right?
Right. They did not purchase those items.
Well, your wife had just said earlier in the part that that she had sold your items, right?
To our landlord.
She wasn't talking about your landlord in this clip. She's talking about Buddy, right?
Exactly. Multiple people have been to my house.
And, okay.
And she also states in there I have 3 of everything.
Yeah, that was referring to your steroids.
No,
right?
3 of each individual. I have 3 nail guns, 3 air compressors, because I do contracting work. The stuff she gave to my landlord, he had it all accounted for. She could not account for everything else when my friend Buddy was in my shop borrowing 1 nail gun.
Yeah. And so you were going to go down and
See if he had it, exactly.
get it back, and then you were going to go straight to the cops and report him for burglary.
Yes, that's called theft. I learned my lesson. He could learn his.
For borrowing. He's going to learn a lesson and get charged with burglary because he borrowed your stuff, as you say here today.
Sustained.
You turn to page 33 in your transcript. So in this same conversation earlier than where we listened to, we can go back and listen to this if you want, you told your wife at line 922 to keep the DECA and HGH for me, right?
Line 22. Yes.
And DECA is a steroid, right?
DECA is a steroid.
HGH is a steroid.
HGH is a steroid.
And then on 924 you said, I'm just kind of bothered that everything I worked for is being sold, right?
Correct.
And this is right before well, a few minutes before the conversation with Buddy that we just listened to, right?
Correct.
And then your wife...
And I'm only referring to the roids on that point, not the tools.
Yeah, and then, exactly, you were referring to having 2 of everything, and then in line 926, your wife says, well, Jason, you have 2 of everything, right?
Right.
So referring to the 2 of everything was in relation to the steroids, right?
It could go both ways. I probably understood that she meant 2 of everything on my tools and the roids exactly. He was to come by the roids and not purchase any of my tools due to them going to my landlord. So when I found out multiple tools were missing when he went over there to purchase the other stuff, I was on the assumption that he had it.
If that's what you meant in this statement, you could have just had your wife go file a police report, right?
That doesn't necessarily how it works.
And if that's what you meant when you said this, when you got out of jail, you could have just gone down to the police department and filed a report for theft, right?
Right, but I would like to have actually seen the merchandise.
But that's not what you told your wife. You told your wife that you were going to go and be all buddy-buddy with Buddy, and then as soon as you got your hands on your stuff, then you were going to go straight to the police department and report him for burglary and call your wife down to sign a statement consistent with that, right?
Correct.
And then you said, as we just heard, that when you get out, he's going to jail. He's going to feel how I feel sitting in here because of a homie just backstabbing him. Right?
Correct.
You said that he was going to feel the way you feel because you were going to go stab him in the back, as you perceived he'd stabbed you in the back.
Correct.
That's all the questions I had, Ron.
Redirect.
Did Martin ever stab you in the back?
No, he did not.
Will you finish your explanation of that phone call, what it was that Buddy had done that angered you?
He took advantage of my wife while I was incarcerated, is how I felt.
Okay. Did he take tools from you?
I believe he did.
Okay. Did you sell tools to him?
I did not.
So you believed he had stolen from you?
Correct. He was the only one at the house other than my landlord during the time of my incarceration.
Okay, so the explanation for that phone call for wanting to go to the police, get your tools back first, go to the police,
Correct.
is because you believed he had stolen from you?
Correct. My wife would be the witness that the tools were there.
Had Martin
Before.
ever done anything like that to you?
No,
Do you have any type of vendetta against Martin?
I don't.
Why did you come forward about what Martin told you?
I believe it's the moral thing to do.
Okay. You said earlier that you were shocked by what he told you.
Correct.
Is it also true that you were hoping to get some leniency on your cases?
Oh, yes.
Okay. I'm going to, if I may approach, Your Honor,
You may.
I'm going to direct you to a phone call you had, you made with your wife on January 20th of this year.
Does he need this stuff back?
It's this yellow part here. K is Christina, J is you.
All right.
Will you read that conversation indicating who is speaking?
Jay, me, says, sorry, I don't have my contacts in. Yeah, I didn't even know the guy when I first came in.
Who are you talking about?
Talking about MacNeill at this point.
Okay.
And then Kay says,
K is who?
my wife.
Okay.
Well, that's just weird that someone would be like that. Hey, I guess what? And then me, Jay. It wasn't like that.
So your wife's saying it's weird that someone would just come up to you and,
Exactly. That somebody would just say something like that out of the blue. And I said, it wasn't like that. We started building a friendship, I guess. He just trusted me. Kay, my wife, says, well, wouldn't you just have to, like, go to court? I say, I will have to testify. Yep. And Kay says, well, I mean, I can't get back around there because that wouldn't be good. Jay, that's me, says, no, it won't. Kay, she says, that's my wife. Well, if you have to go to court over there, are other inmates there? Me, I say, no, his will be all cut off from everyone else. Kay says, that's my wife, says, okay, it's just kind of scary. I say, yeah, but after what I've heard, I need to do what I need to do. Kay says, yeah, I know, but Well, she says, yeah, I know, but you do want. So, like I said, for people to find out. Oh, like I don't want her, or she goes, yeah, I know, but I don't want people to find out.
Okay.
I'm
What,
testifying.
when she says it's scary, what were you talking about?
About me testifying.
Okay, why would that be scary?
In jail, I guess it's labeled snitch.
Okay,
And
sorry, go ahead.
my life could be in jeopardy.
Okay, why don't you go ahead and finish?
I put, baby, I can't take care of myself, or baby, I can take care of myself. His trial is in May, so I will be out before then anyway, the end of May.
Is that it?
That's it.
Okay, thank you. May I approach, Honor?
You may.
I'm going to have you read one more conversation you had with your wife. So this one that you just read is January 20th, 2013.
Correct.
Had you talked to investigators already by that point?
I'm not sure. I believe so.
If I told you that the date of your interview was January 31st, would that strike you as wrong or right?
That sounds more right. More the end of January.
Okay, this is a phone conversation on January 12th. It's a little bit lengthy, but I'm going to ask you to read the whole thing, actually.
Okay.
Again, who is Kay
Kay is my wife.
and who is Jay?
Jay, that's me.
Okay.
But you do realize that classes and all GPS is the worst situation, right?
So this is referring to the worst, what? What is it referring to what?
The worst situation on my sentence,
Okay, okay. So this is your understanding at that time?
that I would get GPS and probation
Okay.
for the remainder.
Where did you get that understanding from?
Inmates in jail, stuff like that.
People just talking like what
What they've experienced, what they've seen, what's happened to them.
Okay.
But my charges weren't as serious as theirs.
When it comes to the plea agreement that you arranged with the prosecution, who helped you work that through?
With the prosecution, who helped me work that through?
No, let me ask you, who was your attorney?
My attorney was Barbara Gonzalez.
When it comes to working out a plea agreement in your criminal cases, or in these criminal cases, did you interact through Barbara, or did you interact directly with prosecutors?
Through Barbara.
Okay. On cross-examination, it was implied that during your interview, there was a prosecutor present. Is that true?
Yes.
Did that prosecutor give you any type of agreement?
No.
Did you ever interact with that prosecutor?
No.
You also were in a phone call, you said something about a prosecutor not giving an F about what was being recommended for your sentence or your sanction.
That's the...
Is that the prosecutor's words? Did you?
No. That was my words.
Okay, that's your characterization of what you understood.
Yes.
Okay. Let's go back to that phone call. So in this phone call, when you talk about working things out with the prosecutor, you're not dealing directly with the prosecutor, you're working through your lawyer, is that correct?
Correct.
Okay.
And then Kay says, yeah. I say, because that other thing Barbara said. Kay says, the last time you were in jail, nothing ever happened with that. Jay says, and that's me, I asked Barbara about that, and she said it was because you were already sentenced. I'm not sentenced now. And she says, oh.
So is this referring to the information you have about MacNeill?
Yes.
It might work out better this time because the sentence hasn't been handed down yet.
Correct.
Okay, go ahead.
So I can make deals now. Oh, okay. And I say, do you get it? She says, yeah. I say, okay. She says, will Barbara tell me? And I said, no, Barbara won't talk to you about it because she's my lawyer. She won't do that. But if I tell her to, she will. So if you want me to tell her, I will. Kay says, I thought you already told her about it. I told her, and then I say, I told her, but I didn't tell her to tell you. She won't talk to you about it because it's confidential. Kay says, yeah. I say, she won't even let me tell her, she won't even let me tell everything.
Okay, let me stop you real quick. So when you're talking about telling Barbara, your attorney, to talk to your wife, that's because Barbara will not disclose confidential attorney-client stuff to your wife unless you say it's okay.
Correct.
All right, go ahead and continue.
And I say, she won't even, oh, I already said that. Did you tell her or not? I say, I can't tell her. Okay, so my wife says, so who do you have to tell? I said, the DA.
Now this is referring, now we're talking about telling stuff about MacNeill, is that correct?
Yes.
Okay.
And I say, the people who are coming down to talk to me. She goes, oh, okay. And then I say, and that case is huge. She says, really? I say, babe, it's like O.J. Simpson, huge.
You're referring to Dr. MacNeill's case, right?
Correct.
Okay.
And she says, and then she's silent. And then I say that after I'm released, I'll go.
I'm going to object to this, but I think it's getting beyond the scope of a question.
It is a narrative. Are we almost done?
We are almost done, Your Honor.
Okay, and let's move on to questions. Go ahead, finish it up.
Okay. Yeah, that after I get released, I'll go and do that. Yes, I'll be there, and I'll be in the papers and stuff like that. She says, all right, but you know what? It's the right thing to do. She says, yeah.
Who says it's the right thing to do?
My wife says it's the right thing to do, and I said, yeah. She says, I say, with what I know, it's the right thing to do. I've got to do it. I got to live with myself, or I'll have to live with myself if I don't. She says, yeah, that's the thing. I say, because what happens if he does it again? And she goes, I know. And then she says, well, that's good. It will help your case, and laughs.
Thank you. So, in this conversation, are you talking about working something out to help your case?
Yes, I am.
What else are you talking about? Well, what do you mean by saying it's the right thing to do? I've got to live with myself.
Even if I didn't get any help in my case, then if I didn't say anything and come forward, I'd have to live with that for the rest of my life, knowing that if he got away with it, knowing with what I know.
So in addition to your motivation for working out a deal on a case, it sounds like you're also motivated by moral compunction.
I know my morals aren't straight, but to this extent, yes.
Okay. Did you get the deal that you were expecting?
No, I did not.
So when you first heard these things and you realized this is important information, what was the deal you were expecting to get? Or hoping to get?
Honestly, that my record would be expunged and I'd be released right on talking to the agent.
Okay. Because this is important information.
Exactly.
Valuable to the state.
Correct.
Is that what happened?
No.
The retail theft charges that you were booked into jail on, did they go away?
No.
What happened with that?
I pled guilty. And they're on my record for a great deal of time.
What about the probation sanction? Did that just disappear?
Probation, I didn't get probation. I got GPS.
Okay, let me ask you, you were booked in also on a probation violation, is that correct?
Yes, sir.
So that probation violation, what happened to that?
I was violated.
It didn't just disappear?
No.
You said you did some time on these cases?
I did.
Is that what you were originally hoping for when you came forward with this information?
Yes.
Let me ask you a better question. Were you hoping to do some time?
No.
Were you hoping that this information you had would help you not do some time?
Yes.
Okay, but you did time anyway?
Yes.
And you're still here today?
Yes.
Let me ask you, are you on probation still?
No.
Are there any promises that you're expecting from the prosecution once you're done testifying?
Other than the immunity, no.
Okay, let's talk about that immunity. What's your understanding of what the immunity that's been granted to you is?
That what I say about some of the cases or some of the legal activity I was involved in, they cannot put further evidence into what they were already investigating.
Okay, so we've talked today about a Rolex watch scheme. You understand that could be illegal?
Yes.
Steroids illegal?
Yes.
Selling prescriptions is illegal?
Yes.
Have we promised you that we will not prosecute those crimes?
No.
In fact, if we get evidence of those crimes, we could still prosecute for those, right?
Correct.
We just can't use what you're saying today as evidence.
Correct.
So the immunity you've been granted is actually it's pretty narrow.
It's a little too narrow.
You comfortable about being here today?
I am, but I just got to do what I got to do.
Okay. Is it fun having your past misdeeds paraded in front of everybody?
No, because I just got a business, and I'm fearful of my business not succeeding.
So in addition to, things being scary because you might be labeled a snitch, could your testimony today affect your business?
It's affected my life, yes.
How so?
I'm changing my life, and people are going to portray me as an evil monster.
Okay. You have customers, clients watching this?
Yes, they are.
Okay.
I've informed them of what I'm doing.
Okay. You worried about losing those guys?
I'm going to check. This line of question is very leading.
It is leading sustained, but sustained as to leading. You may rephrase.
Okay. Do you stand to lose customers from this?
Yes.
Do I have 1 minute, Your Honor?
You may.
Mr. Spencer asked you about telling your wife to put money on Martin's books in jail.
Correct.
Whose idea was that?
Mine.
Okay. Did Martin benefit from that?
He did.
How so?
He would get a percentage.
Okay. So you can't do commissary. You're doing it through him, but he's getting a cut.
Yep.
Will you explain what happened with USU, your baseball prospects there?
When I went to enroll, we moved out to Logan, and I went to talk to the baseball coach, and he told me due to regulations of my age, I could not try out unless I played for a junior college for 2 years first.
Did you move your whole family up to Logan?
I did.
So you're not enrolled now?
I'm not.
When you were being sentenced in June, was this before or after you'd been told about your eligibility?
This was before.
Okay, so since then it hasn't panned out.
It has not panned out.
You still have hopes to go to college?
Yes, I got to play. They told me to go to Slick and play for their junior college.
Okay, and then maybe you can qualify?
And then maybe I can qualify. I have to have some college.
Okay. Are you aware that if you're lying today, you could be charged with felony crime of perjury?
I sure am.
Are you aware that if you lied to Investigator Robinson during your interview, and if we find out about that, we could prosecute you for felony obstruction of justice?
I sure am.
Did you make up anything about, did you make up the statement that Martin made to you about, well, for instance, I killed my wife, that should say a lot?
No, I did not.
Did Martin in fact say that to you?
He did.
Objection, Your Honor, asked and answered.
I'm asking this in the context of his Impeached credibility, Your Honor.
Overruled, it goes to rebutting motive. Go ahead.
Thank you. Did you make up Martin's statement, "Don't worry about it, I'm glad the bitch is dead," to get something
No.
out of prosecution? Did you report it to get something?
No.
Let me ask you that. I'm asking a careful question. Did you make it up to get something from prosecutors?
No, I did not. That's what I assumed you were saying.
Was your hope that you'd get something out of prosecutors part of the reason you reported it?
Yes.
Okay.
Figured to help my case.
And the other part is because you felt it was the right thing to do?
Exactly.
Did you make up the statement that Martin told you that he and his wife would fight about her assumptions that he was cheating?
No.
Did you make up the conversation when you asked him, "Hey, are you joking about this stuff?" Martin saying, "Does it look like I'm joking?" Did you make that up?
No, I'm pretty sure you can see that clearly in the jail video of him throwing his hands up.
So if there was a jail recording of this, you'd be able to see him doing this
Yes.
motion, throwing his hands up. Okay. That's all I have.
Any recross?
May I approach, Your Honor?
You may.
Mr. Poirier, after your meeting with the investigators on December 31st, 2013, January 31st, 2013, you wrote out a statement about what Mr. MacNeill allegedly told you, right?
Yes.
And this is that statement, right?
Yes.
And that statement says that there were two conversations, according to you. On December 17th was one and December 19th was the other, right?
Correct.
And you wrote out what was discussed in those two conversations, right?
Correct.
Would you point out to me in that statement where you said that Martin told you anything about having a fight with his wife?
I believe I did not write those down.
Would you point out to me in that statement where you wrote anything about his wife being tired of him having an affair?
I don't believe I wrote those down.
You didn't write it down, and you didn't say it in your interview either, did you? Today's the first time you've said that, right?
No, it's not the first time I've said that.
Well, where have you said it before? It's not in your phone calls. It's not in your interview. It's not in your
This is not
statement.
in my phone calls.
No, I'm not talking about these statements that you've testified to today about the alleged fights with his wife. I mean, you didn't say those in your telephone calls, right?
No, I did not.
You didn't say it in your
Say
interview.
anything in my telephone calls.
You didn't say it in your interview with Investigator Robinson on the 31st, right?
I believe I did. The interview with him.
Well, is
About him throwing his hands up.
No, I'm talking about your statement saying that Mr. MacNeill allegedly talked to you about his wife and having a fight with her and having affairs.
I believe I came forward with just the three big ones that I knew were very serious. I didn't really think a fight with his wife was relevant.
They asked you a lot of questions in that interview, even said anything else that we need to know. And you never said anything about these things in your interview, right?
No.
And you didn't say it in your statement.
No.
And today is the first time you've brought that up. You've certainly seen a lot of media coverage about Mr. MacNeill since your interview, right?
I have not.
Not at all?
Not at all.
Okay. You indicated that you're testifying here because you feel it's your moral obligation, right?
Correct.
You have never been charged with fraudulently selling Rolex watches in 2012, correct?
Correct.
Even though there's been 3 counts that have been filed with the police, you haven't been charged with those, right?
Correct.
Those would be felonies, right?
Correct.
You haven't been charged with distributing prescription medications from Dr. Moore,
Correct.
correct? You understand those would be felonies, right?
Correct.
You haven't been charged with distributing steroids.
Correct.
You understand those would be felonies.
Correct.
And there's been evidence in relation to those in your phone calls from, going on a year, 10 months.
If I never came forward, they wouldn't even known about the roids and prescriptions.
Unless they had listened to the telephone calls that were being monitored, right?
Tons of stuff that people say on phone calls. They're not prosecuted.
You think there's tons of people in the jail that are arranging to distribute prescription medications and steroids on phone calls?
Yes.
You felt that you could do that because you were important to the state, right?
No.
They needed you, is what you said.
No.
Right. At least in relation to the Rolex watches, you knew that they were investigating that and submitting that for charges, right? When you were booked into jail in December.
Actually, I had the information before they even booked me in on that.
That's my point.
They arrested me, or they charged me with it a few weeks after. I was booked in, and I had the information about MacNeill.
As far as the Rolex watches, though, that came about the day, as far as you being arrested in relation to that, that came about on the day that you were arrested on December 10th of 2012, right?
They confiscated the watches, yes. They did not charge me that day.
And so, right, well, they've never charged you with it, right?
I was fingerprinted.
You were fingerprinted, but you've never been charged, right?
I was charged, went into court, and they said they did not have evidence, and they dismissed it for further notice.
They said that they couldn't proceed at that time.
Exactly.
Right? And since that time, you haven't been charged.
Exactly.
Right? And so this letter that we talked about initially to Judge McVeigh was actually in January of 2013, right?
Right.
So it was January of 2013 that you were telling Judge McVeigh that that you couldn't live without your wife and daughter.
Correct.
Right? And you were worried about your wife leaving you if you were going to be in jail for a long time, weren't you?
Correct.
And you knew that that Judge McVeigh had already seen the recommendation from your probation officer on January 7th.
And he knew about the rest of my cases?
And then before you entered your plea, there was an arrangement for the judge to be changed, right?
Correct.
And so you didn't actually enter your plea before Judge McVeigh, right?
Correct.
And you entered your plea before Judge McDade.
Correct.
So he never saw the recommendation from your probation officer, Tammy, correct?
Objection.
I'm not sure.
Speculation.
Sustained.
You had a whole lot to gain by providing information to the prosecutors that they needed in January of 2013, didn't you?
And I have a whole lot to lose.
And you didn't come forward to any authorities until after January 7th, when you realized what Tammy was recommending for you.
No, she told me what she was recommending when she was driving me to jail. I knew what she was recommending.
In other words, after December 17th or December 19th, you didn't contact any officer in the jail and say, hey, Mr. MacNeill just confessed to murder to me, did you?
Say that again.
After your conversations that you allege on December 17th and December 19th, you didn't pull a deputy aside at the jail and report that Mr. MacNeill had allegedly just confessed to you to homicide, did you?
No, I reported that to my lawyer, not Barbara Gonzalez, a paid lawyer.
And you didn't report it to anybody at the jail, did you?
After the third conversation, I reported to the deputy to move me.
And, well, you were with Mr. MacNeill getting care packages up until, we have phone conversations went over through December 31st. You were still getting money to help you buy commissary and care packages sent to him through December, right?
Correct.
And in your statement and in your interview, you only referenced 2 incidents on December 17th and 19th, right?
I believe with my talk with the agent, I said all 3.
Would you look at the last statement that you write on that
On my letter,
statement?
or
Yeah, Coach Arnold?
May.
on my letter?
Yes. Well, maybe turn back to the first page. So you referenced one conversation on December 17th in your statement, right?
Mm-hmm.
And one on December 19th,
I did.
right?
And then this was talking
And then
about
that's your
his,
last statement.
we have not talked since this incident with
Well, this is all
his
under
date,
December 19th, right?
right?
And you say we have not talked about his case since. That's what you
Right,
wrote.
and we talked
Right.
after this, after I wrote that.
Well, this wasn't written and submitted until February 15th, correct?
Correct?
So this was written after your interview.
No, that was written before. Before my interview with the
Yeah.
agent, that's written before.
So when did you write this statement?
I believe it was after first few days after being in the same pot as him.
Did you mention that in your interview?
That I wrote those statements down?
Yes.
No. In my interview, I just mentioned what he said.
Okay. And you didn't mention anything in this statement about him talking about his wife cheating on you, or not cheating on you, I'm sorry, about Mr. MacNeill allegedly talking about cheating on his wife.
On that paper, no, I did not.
And so you're saying that this paper was written closest in time to what you allege he
And
said
I heard after, yes,
in,
and stopped taking notes
okay,
because I felt like I was out of the pod and I was fine.
okay. And so,
And my interview with the agent was already said.
and then that interview with the agent wasn't until January 31st, correct?
I believe so, yes.
Of 2013. And now in your statement, in fairness, I want to correct one thing. Do you still have the
I have
interview
two of them.
transcript up there?
With the agent?
Yes.
Yes.
So turn to page 14. Well, may I approach on it?
You may.
So this statement, from what you're saying today, was, your interview rather, was approximately a month after you allegedly wrote these things down on your letter, correct?
Correct.
And so if you look at line 411,
Shut that off. Who has that? Shut that off. You come up, please.
so in fairness, in your interview, Deputy Robinson did ask you this question at line 411. Let's see, did he ever talk about arguing with his wife, any other details like that about his wife or whatsoever? And I'm just asking about things that you actually recall, not things that you suppose, right? He asked you that question?
Yes.
And then you say the only thing he ever said that they would fight about was that her assumptions of him cheating on her.
Correct.
Right? So you did say that part in your interview in response to his questions.
Yep.
Right? Okay.
He was bringing out more stuff out of the conversations we've had. There's a lot more too.
And
that I have not revealed.
And then we moved to strike that. It's non-responsive.
Strike
It's
the last statement, last sentence.
Yeah.
That motion's granted. Go ahead.
Without this deal that you've got on the charges, you would have been separated from your wife and daughter for a long time, correct?
For a year, yes, I would have.
For a year, you thought, yeah? And without this deal, you easily could have been charged with felonies for the Rolex watches, distributing steroids, and distributing prescription fraud, or distributing prescription medications as well,
Objection.
right?
Assuming facts, not in evidence.
Overruled, he may answer.
No,
You don't think so?
I don't think so.
Okay. And so that's just criminal conduct that you thought you would just be able to get away with?
Correct.
Okay. That's all the questions I have.
Thank you. Do you have anything further?
Yes, please, Your Honor. You remember everything about your interview on January 31st? Remember every single thing you said?
Pretty much, yes.
Every word that you ever said to Investigator Robinson? Are you able to recall that without looking at it?
Yes, I can't word for word, but
Not word for word.
I can say some things, yes.
Okay. So Mr. Spencer asked you if you'd ever said before today whether Martin told you anything about arguing with his wife that he was always cheating on her.
Correct.
And at first, when he was pushing you, you said, "Well, I thought I said it back in the interview, but maybe I didn't."
Correct.
And Mr. Spencer found it. You did actually say it back in the
Correct.
interview, correct? This written statement that you've made, actually, I'm going to take you back to your interview. If I can show you this transcript. I'm going to have you read I have to read 49 to 50, these parts that are underlined.
Says, thought about it, wrote about it. That was in December 17th, and it was right after cleaning our cells. So it was in December 19th.
Okay.
18th.
Thought about it, wrote about it. What were you talking about just before that?
Just thought about what he just said to me.
which was?
Was about the I can get away with a lot of things,
Such as?
like killing his wife.
Okay. I'm going to show you the written statement that you've made. What's the date on the first paragraph?
December 17th,
What's the date on the second paragraph?
December 19th.
And then the final sentence is that you hadn't talked to Martin about his case since then,
Right.
since you wrote that statement. Is that correct?
That I didn't talk to him after the 19th.
No. Let me ask you, when you say I haven't talked to him about his case since,
Right.
was that written on December 19th?
That was written that same day.
Okay. Did you, after you got done writing that, did you have subsequent conversations with him?
Yes, we did.
Okay. I'm going to have you look at your transcript. We've had a question about whether you had 3 conversations with Martin about this, or 2. When you talked to Mr. Robinson on the 31st, you said that first conversation when you asked him about his shoes, and he said, for instance, I killed my wife, that should say a lot. That happened on the 17th, and you wrote it down.
Yep.
Then you said second time was on the 19th.
Correct.
And that's where he said, don't worry about it, I'm glad that bitch is dead.
Correct.
You wrote that down.
Yes.
Okay, and then later in that same discussion with Investigator Robinson, you said, the last time we came out for rec, is that the third conversation you're talking
That's
about?
the third conversation.
Okay, I went up to him and said, hey, are you joking about this stuff? And he said, does it look like I'm joking?
Correct.
Okay, so 3 conversations.
Correct.
Third one happened after December 19th.
Correct.
After you wrote that, I haven't talked about it since.
Correct.
Okay.
That's when I asked the jobs to switch me pods, and
When, so you're having these conversations with Martin. Once you figured out he was serious about it, what did you do?
I told the deputy to switch me pods.
Okay, and about when was that?
Probably the 20th or so
Of?
November. I mean December. I apologize.
Okay. So, even though you didn't necessarily report it to deputies right away saying this guy is confessing to murder, you did take action.
Correct.
Okay. Are you telling the truth today?
Yes, sir, I am.
Okay, that's all I have. May I approach to?
Thank you. May the witness step down.
Your Honor, I've got just a little bit of follow-up.
Is there anything new raised in
It's only in relation to what's been raised.
It needs to be. Go ahead.
So in this letter, if this was written on December 19th, what would be the point of writing, we have not talked about this case since? If it's written
Because
on
that was the
same
end of the day.
Okay. And do you still have the phone records up there?
Yes.
And if you turn to page 10, as late as January 2nd, your wife was sending care packages to you through Mr. MacNeill, correct?
As late as what?
As late as January, this is referencing a phone call on January 2nd of 2013.
Yes.
And so in that phone call, you discussed a care package that your wife had sent you through Mr. MacNeill.
Correct.
Correct? All right, that's all the questions I have.
Thank you. May Mr. Poirier be released from his trial subpoena?
Before that, Your Honor, we'd like to know if there are questions from the jury.
Thank you. Do you have any questions for this witness? Pass them to the end of the row, please. Counsel, will you approach?
GPS is still part of the jail. It's a confinement to your house. You're still jailed.
Do you have follow-up questions?
Just a little bit. Confined to your house, how do they enforce that?
They put an anklet bracelet around your ankle so they can know your whereabouts at all times.
Okay, through the GPS system?
Yes, sir.
Okay, that's all.
Anything further?
No, Your Honor.
May he be released from his subpoena then?
Yes, Your Honor.
Any objection?
No objection.
Thank you, Mr. Poirier. You may step down. How long will you be with your next witness?
I think upwards of possibly an hour, Your Honor.
Okay. At this time, ladies and gentlemen, we'll break for our lunch. During the examination of Mr. Poirier, there was some kind of media broadcast that you began to hear from a computer. I'm going to order that you disregard anything that you might have heard. I know that it was very brief. There doesn't appear to me to be any substance that was broadcast here in the courtroom. You're to completely disregard that. It has nothing to do with the case. It's not evidence in the case. Evidence consists solely of witness testimony, documents and things admitted here in court, and that media broadcast certainly does not constitute that, and you should fully disregard it. Please keep in mind my prior admonitions to you. It's your duty not to discuss any subject of the trial with each other or with anyone else. It's your duty not to form or express any opinion about how the case should be decided until it's finally submitted to you. Avoid television, radio, or internet news coverage of the trial. Do no research on your own. If you would come back at 1 o'clock, please. Court's in recess.
All rise.
Thank you. Please be seated. What's today? Counsel, I'd like to make a further record about what happened during Mr. Poirier's testimony. During cross-examination of Mr. Poirier, a computer apparently behind the prosecution's table began playing what is clearly a media broadcast. The voice of what appears to me to be a woman reporter made a general reference to the criminal trial of Dr. Martin MacNeill. When I heard that, I interrupted with, in a loud voice, my objective to drown out what was being heard, asking, whose is that? Shut it off. Whose is that? Shut it off. I used a loud voice for that purpose, and I want the record to reflect that. My view is that the only thing that was audible is this today in the trial of Dr. Martin MacNeill, or I don't even know if it said today, but a general reference to the trial of Dr. Martin MacNeill. Do you wish to make any further record in that regard?
No, Judge, I believe that's accurate, and for the court's knowledge, we've instructed our team that we will not follow any broadcasts, any media coverage of the case while in court.
Thank you. Any further?
You know, I believe that there was more heard than that. I think I was either standing at the lectern or up near Mr. Poirier. I don't remember which one.
You were closer than me, so what do you believe?
I recall hearing a discussion about the bathtub, about his wife being found in the bathtub.
There will be no audible anything from the gallery. That needs to stop. If I hear it again, you'll be excused. Go ahead.
That's my recollection, and I'd be happy to listen to the court recording. I'm fairly confident that was said in relation to the trial of Dr. MacNeill and his wife being found in the bathtub, and then there was a little bit more said that Your Honor was talking over, and I didn't hear any more clearly than that. And I think it's prosecutorial misconduct to be doing things like that during the middle of my cross-examination. For purposes of the record, we've moved for a mistrial.
Okay. Do you wish to be heard on the motion?
First off, Your Honor, I did not recall hearing anything about a bathtub, anything substantively as far as the facts of this case. Certainly in the introduction, which the court heard, and then the court began speaking in a loud voice, but I don't recall hearing that. As far as prosecutorial misconduct and this constituting a mistrial, I think that is not even close. The remedy would be to a mistrial at this stage. I think the court has instructed the jury to disregard it. I don't think there was anything substantive that was even heard about the trial. In addition, I don't think that there was anything that would have added to the facts of this case, even if something was heard with respect to a bathtub, which I don't recall hearing at all.
Let me ask you this. I don't know if this, I don't even know what was played. I don't know if it was live streaming of something or if it was a recording of something that has been broadcast before.
If I can inquire.
Yeah, can we just find out what it was?
I'm told it wasn't anything that was happening today, or certainly not live today. It appeared to have been a report about something previous to today.
Can it be recovered so that
We can try and pull up what we think was...
I'd like you to try and recover it so that the record is clear that, about what was heard. The only thing that I heard is in the trial of Dr. Martin MacNeill, at which time I began to speak. I wasn't listening to anything else at that point. I don't think it went beyond 10 seconds. But I'd like to know from that point to what, to its termination, maybe 10 to 15 seconds at best, 15 seconds, so that the record is clear if it can be recovered and that you're confident that that's what was played.
We'll try and do that, Your Honor.
And then if you could provide it to defense counsel, our reserve ruling on the motion for mistrial until we get started at 1 o'clock. Court's in recess.